My name is Phil Shackleton. I'm a lead partner in MC's Insolvency, Recoveries and Enforcement Group. I was counsel in the Debut Homes litigation in all courts, from the High Court all the way through to the Supreme Court. The Debut Homes litigation was the first time that the New Zealand Supreme Court had squarely considered the issues of directors' duties. The Supreme Court's decision in Mainzeal has been keenly anticipated for some time. The Mainzeal litigation itself has been high profile in New Zealand from the start. It's been newsworthy given the sums involved, the relatively high profile that Mainzeal had prior to its collapse, and the parties involved in the litigation, including one of the defendants being a former Prime Minister of New Zealand. But perhaps more importantly, the decision has been keenly anticipated to see whether the Supreme Court might move from aspects of its earlier decision in Debut Homes. Debut Homes has come in for some criticism from some sectors as being uncommercial and for raising the risk profile and uncertainty for directors, particularly as directors head into more troubled economic times. At a high level, the Supreme Court has upheld the Court of Appeal's earlier findings that the directors breached their duties under Section 135 of the Companies Act, which is the reckless trading duty, and the duties under Section 136, which is the prohibition on directors causing or allowing companies to incur obligations when they don't have a reasonable belief that they'll be able to be met when due. In reaching its decision, the Supreme Court has ordered the directors to pay compensation of some $39.8 million plus interest, with the liability of 3 of the 4 directors being capped at $6.6 million plus interest. Given the length of time that this litigation has been ongoing, some 10 years, my expectation is that interest liability will be significant and may well push the total judgment sum over 50 million New Zealand dollars. Rather than move away from the position it took in Debut Homes, the Supreme Court reaffirmed key aspects of Debut Homes, including the creditor protection focus of both Sections 135 and 136. In reaching its decision that the directors had breached their duties under Section 135 and 136, the Supreme Court gave particular focus to the fact that Mainzeal had been trading for quite some time with generating minimal, if any, operating profit, that external advice that had been taken recommended a capital injection, which hadn't been forthcoming. Supreme Court also focused on the fact that the directors were aware of Mainzeal's troubled financial position, and that the assurances of support from related parties were neither legally nor practically enforceable, to the point that the directors could not reasonably rely on those assurances. The Supreme Court's judgment some 140 odd pages, and there's a lot to unpack in that judgment. One of the most important aspects of that judgment, from my point of view, is the advice and additional guidance provided to directors. In giving that advice, the Supreme Court acknowledged itself that the issues that it was grappling with in the Mainzeal litigation was of fundamental importance to the business community. In terms of its guidance to directors, the Supreme Court has reaffirmed the position that it's an obligation of directors to regularly monitor the financial performance of a company, and that obligation is a continuing obligation. And where the directors identify risks, either due to the solvency position of the company or other adverse risk factors that give rise to concerns or risks that the directors may be breaching their duties under Section 135 and 136, then the directors need to directly address those risks and concerns, assess the position, and if they can, put in place a plan that directly addresses the risk factors identified, and gives rise to a reasonable belief that those risks can be addressed if the company continues to trade. Of importance, the Supreme Court has reaffirmed that the directors will have a period of time, albeit perhaps a limited period of time, to make that assessment and put the plan in place. What that time period may be will depend on the circumstances, including the urgency of the situation and the complexity of the situation facing the directors. While directors may not be in breach of the reckless trading duty generally during this period of assessment, the Supreme Court has held that, or commented, that directors may well still breach their duties if during this assessment period the directors cause the company to generate significant new obligations without a plan in place to meet those obligations. Equally, the Supreme Court's reaffirmed the position that a company trading for a long period of time while balance sheet insolvent will generally trigger a breach of the director's duties unless there are legally enforceable or practical assurances from third parties to assist the company with meeting its obligations during that trading period. Supreme Court's also reaffirmed that it'll often be appropriate and necessary for directors during this period of assessment and trading forward to take appropriate, independent professional advice, in my suggestion, from accountants and legal advisors. The Supreme Court's also commented that the advice taken by directors must be taken into account in an assessment of the reasonableness of a director's actions at the time.